स्टेनो एस्पिरेंट्स। इस मैटर की पीडीएफ और डिफ़िकल्ट वर्ड्स की आउटलाइन के लिए आप टेलीग्राम चैनल ज्वाइन कर सकते हैं। सो बी रेडी, स्टार्ट। बोथ द इम्पंक्ड ऑर्डर्स issued by the respective governments in 1990 and 1991 reserving appointments and posts for socially and educationally backward classes of citizens without discharging their constitutional obligation of examining if the identification of backward class by the commission was in consonance with constitutional principle and philosophy of the basic feature of the constitution, and if the group or collectivity so identified was adequately represented or not, which is the sine qua non for the exercise of the power under Article 16(4), are declared to be unforeseeable. Reservation in public services, either by legislative or executive action, is neither a matter of policy nor a political issue. The higher courts in the country are constitutionally obliged to exercise the power of judicial review in every matter which is constitutional in nature or has potential of constitutional repercussions. Constitutional bar under Article 16(2) against state for not discriminating on race, religion, or caste is as much applicable to Article 16(4) as to Article 16(1), as they are part of the same scheme and serve same constitutional purpose of ensuring quality. Identification of backward class by caste is against the constitutional. The prohibition is not mitigated by using the word only in Article 16(2) as a cover and evolving certain socio-economic indicators and then applying it to caste, as the identification then suffers from the same vice. Such identification is apt to become arbitrary, as well as the indicators evolved and applied to one community may be equally applicable to other community which is excluded, and the backward class of which is denied similar benefit. Identification of a group or collectivity by any criteria other than caste, such as occupation social educational economic criteria ending in caste, may not be invalid. Social and educational backward class under Article 340 being narrower in import than backward class in Article 16(4), it has to be construed in restricted manner, and the words educationally backward in this article cannot be disregarded while determining backwardness. Reservation under Article 16(4) being for any class of citizens and citizen having been defined in Chapter 2 of the Constitution includes not only Hindus but Muslims, Christians, Sikhs, Buddhists, Jains, etc. The principle of identification has to be of universal application so as to extend to every community and not only to those who are either converts from Hinduism or some of who carry on the same occupation as some of the Hindus. Reservation being extreme form of protective measure or affirmative action, it should be confined to minority of seats, even though the Constitution does not lay down any specific bar, but the constitutional philosophy being against proportional equality, the principle of balancing equality ordains reservation of any manner not to exceed 50%. Article 16(4) being part of the scheme of equality doctrine, it is exhaustive of reservation. Therefore, no reservation can be made under Article 16(1). Reservation in promotion is constitutionally impermissible, as once the advantaged and disadvantaged are made equal and are brought in one class or group, then any further benefit extended for promotion on the inequality existing prior to be brought in the group would be treating equals unequally. It would not be eradicating the effects of past discrimination but perpetuating it. Economic backwardness may give jurisdiction to state to reserve provided it can find out mechanism to ascertain inadequacy of representation of such class, but such group or collectivity does not fall under Article 16(1). Creamy layer amongst backward class of citizens must be excluded by fixation of proper income, property or status criteria. Reservation by executive order may not be invalid, but since it was being made for the first time in services under the Union, propriety demanded that it should have been laid before Parliament not only to lay down healthy convention but also to consider the change in social, economic and political conditions of the country, as nearly 10 years had elapsed from the date of submissions of the report, a period considered sufficient for evaluation if the reservation may be continued or not. Stop. Thank you.